Yeah, thank you very much again for inviting me to talk this morning. So briefly, I'll be talking about the work of CMI and MASS. So I've been asked to talk about that subject, for which obviously I'm pleased to talk about it briefly, just to give you some insights into the work of the CMI, what it's been doing, and where we're heading to in terms of regulating matters that are essential for the commercial operation of MASS in the future. So just a little bit of background. If I may take you to PowerPoint slide 3 now. So I'm yes. So the work on just to guide you through where we are. So everything, as far as the work of CMI is concerned, everything actually started back in 2015, and CMI decided to set up an international group, working group on MASS, considering the importance of this matter for the future operation of new technology vessels. And the chair of the group, I'm sure many of you will know, is Tom Burt-Reynerson. And back in those days, I wasn't involved, but obviously they did an incredible amount of work also back in those days, dealing with a wide range of issues to start with. So obviously the first idea there was the main purpose of the group was to get some ideas, views about how MASS can be integrated into the legal framework, whether it will be possible for these vessels to operate initially together with conventional vessels and eventually, ultimately, on their own at seas. So the major task of the CMI was obviously, because we obviously do know CMI's role in regulating international shipping matters, legal issues. So naturally, the first major task of CMI was first to check and see the compliance issues. So we have got a lot of obviously conventions. Mainly, they initially looked into those promulgated by the IMO, the main conventions promulgated by the IMO. To see whether they're compatible with MASS. So they looked into specific conventions that IMO promulgated. And they also delved into the issue of how the countries would react to the operation of MASS. Because in essence, we talk about not just vessels that can be remotely controlled, but also the references there to those that can, with some algorithmic decision making, can execute decisions on their own without the involvement of any human tasks that are traditionally carried by very competent masters and seafarers. So because of the unique nature of this thing, it was quite important, as we can all see, for the countries to respond to these likely changes in this shipping sphere. And so looking at the conventions, so these are the ones. So if I may take you to PowerPoint slide 5. So I've listed there the conventions that the CMI initially looked into for compatibility purposes. And the major thing that they wanted to identify was which ones would require some amendments if MASS starts, let's say, to operate, which ones would need some amendment. So red flag there, obviously, some regulatory steps need to be taken for those conventions. Clarification, so some conventions may not necessarily need any amendment, but there may well be some need to get some further think about more about how to work it out. So not clear. So looking at the convention itself, when it is not clear whether it will be compatible with MASS or not, some further clarification would be needed in respect of the application of those conventions to MASS. So that's the second category, that any convention can be brought into. And the third category was no action required. So there was some sorting that was done by the International Working Group to find out which conventions can still work without any alterations needed, which conventions would require some work for either clarification or amendment purposes. Quite a chunky, voluminous documents, bundles were created for that. A very valuable work of the CMI that was carried out back in those days. Also important, I think, was the questionnaire that the CMI prepared for the country's representative to respond, to give their responses to. So CMI approached maritime associations of each and every country, asking questions about what their thoughts are about MASS when we don't have masters crew on board. Do they actually think that the conventions, many of which require some master assistance, etc., would still work? So obviously, back in those days, there was this very obvious question of whether we can define MASS as ship. So we no longer deal with those seemingly simple questions. We have now delved into even more complicated matters about the operation of MASS and whether the existing legal framework can actually accommodate. That's a big question, right? And it has got various aspects, and very important initial steps were taken back in those days by the CMI, doing a very important, obviously, research on the issue of what IMO conventions would work, what IMO conventions would need some amendment. And I think it was also quite useful for the CMI to ask the country's representatives about their thoughts about whether they think their national laws can successfully address the issues arising from the operation of MASS. So quite important documents were created back then. So not all countries replied to CMI questionnaire. So I've also there listed in the PowerPoint slide 4. Sorry, I'm just going forward and backward at times. So not every country gave their responses to that, but a good number of country representatives got back and provided their views to the CMI. By the way, all these are available on the CMI website. If you want to take a look at it, you'll be able to see the whole historical work dealt with and the initial steps taken by the CMI on the topic. So that was back in 2015, 2016, and 17. So currently, what we have been doing, so this obviously is a time when I started to get involved. So we're talking about recent years, 2022. So this is a time when I started to get involved in the work of CMI. So we first started our discussions, well, probably there was some preliminary discussions that took place before me, I'm sure. So there was the CMI conference in Belgium, and the international working group at that conference got together, and there were some representatives from the IMO, and the first idea that came up that CMI can help the IMO with the regulation of MASS was to think about the concepts, so the common concepts that are in use for conventional vessels and the extent to which they can make sense, whether they can apply to the new entities. So the idea was whether we can actually define or redefine the concepts that we are too familiar with when dealing with conventional vessels, whether we can still make use of those concepts when we have MASS. So obviously the reference there was to the concept of, for example, master. So who is going to be defined as master when we have got MASS? Who is going to be defined as a seafarer when we have got MASS? So, which is a very interesting issue. So that was the initial thought that we had, and we thought we could help the IMO by identifying, so giving some brief definitions of how master can be defined, how seafarers can be defined. But as I'm sure many of you have those who got somehow involved in policy making, legislation drafting, definition is the most difficult thing to do. and ultimately we sort of realized that it will be difficult to define the elephant. Yeah, so you can obviously see the elephant and try to define it. So looking at its characteristics, shape and size and everything. But in any case, it will be a difficult task to do. So ultimately, the dominant view of the group was that instead of trying to define things, the best way to approach regulation would be to have a more functionality approach. So considering what functions are to be carried by mass. So traditionally, those functions could be carried out by humans, but we need to consider and have more goal-based approach to regulation than try to define things at the outset. The other complication here about definition is we're talking about an ever-changing technologic systems, right? This is going to change. We will first start with remote-controlled vessels. At some point, there's going to be some autonomous vessels. The autonomy level will differ. Eventually, there could be, it sounds like a science fiction, but we may well be in a position to see vessels that can operate completely autonomously, but obviously because of the political considerations, social considerations, there will always be a need for some humans to have supervisory control over these vessels. But when it comes to their capabilities, maybe this is not actually a science fiction. It's perfectly possible to have fully autonomous vessels at some point in time. And that actually means that in terms of regulating matters, it's quite a difficult task to define things when you know that technology will change over time. And that is why the dominant view was then that maybe it's not perhaps a good idea to try to define things at this very early stage. So our focus was then shifted to producing a research paper to provide some in-depth analysis of the liability issues. So we're talking about, if you look at the members of the international group, we're all lawyers, academics, and we want to delve into some intricate, complicated legal issues. Obviously, that we see that will arise when MASS will start to operate. And this interesting topic that came up to our minds is tortious liability. So not everything is governed by the IMO conventions, and we thought it might be useful to provide, to assist IMO with a research paper to show our views. Not decisive necessarily. We didn't put any strong views on what the law should be on these matters, but we placed some emphasis on the need to think about liability issues from a general perspective. Because obviously these are the matters that are important, and when courts will start to look into matters, disputes arising from operation of MASS, obviously our minds will be pretty busy with the operational issues and liability issues arising from the operation of MASS. So the purpose of the paper was therefore to identify what legal challenges we have for the purposes of resolving liability issues, what strategies can be employed, so how to tackle liability issues from, again, a general perspective. And again, I think it's worth mentioning that the research paper doesn't express any strong views about what the law actually should be. So why have a paper on liability? It's a complex matter. We lawyers want to obviously keep our minds busy with complicated legal matters. That's our task. And especially as academics, that's also what we like to do. And that's what we thought would be best way for us to help the IMO. So MASS obviously presents different challenges because of the autonomous systems that will be fitted into vessels with self-learning capabilities. And that means that there will be some liability gaps when MASS starts to operate. And that liability gap is mainly because of the algorithmic decision making that will take place, where it will be not possible in some cases. It may well be difficult to attribute any fault to anyone when these machines systems have these self-learning capabilities, making autonomous decisions. It may not be the fault of the programmer that the outcome didn't turn out to be a right one. So who shall be liable when something happens, when some damage is caused by algorithmic decision making, is an important topic. And this paper delves into the issue with reference from the perspective of tort liability. So the main purpose is there for that. And there are two aspects there. So there is some reference made to product liability, which is quite an important topic, obviously, because we will see more technological glitches and errors and everything causing problems, causing losses when the vessels are in operation. And quite likely human error will no longer be the main culprit of accidents at sea. And that obviously puts in place product liability in a very sort of special place. And that is why it's quite important. And that is why there is some reference, although very brief, made in the paper. So there is some brief discussion there on product liability as well. But the main issues are covered in the paper. So the first aspect is the vicarious liability of the owner. So the paper quite correctly, I believe, sets out the fact that whoever manufactures these systems, ship owner should be the entity that is primarily liable for the accidents, losses, damages caused by their vessels. The extent to which they can exclude themselves of liability, on what legal grounds, are obviously separate matters. But I think it's quite important to first accept as a general proposition that they are the ones that are primarily liable, and some sort of vicarious liability concept as a tool can be employed for the purposes of giving parties some relief when they want to get their losses arising from some accidents at sea. So the paper therefore defends the concept of vicarious liability and advocates its use to the widest extent possible. So remote operators can obviously, through their acts or omissions, if something happens, then perhaps owners can be vicariously liable. So that's one suggestion. But vicarious liability as a concept, I looked at it and did some research on that. And there are some similarities between the approaches taken in English, in civil law and common law jurisdictions, but there are some nuances as well. So quite likely that concept might help to hold ship owners liable when the remote operators cause some loss or damage. Most cases may well be possible, but of course, in every jurisdiction, there will be different legal grounds for holding the ship owners liable, and the concept of vicarious liability and how useful that is, how that is framed, how that is defined. It obviously differs from jurisdiction to jurisdiction. So there is no uniformity, obviously, between the jurisdictions' legal systems in relation to the application of that concept. Concept of fault is also quite an interesting concept issue, and the extent to which that can apply when the MASS operates is interesting and important matter to look into. So the paper also briefly deals with the concept of fault, the extent to which it can still apply to tortious claims, because obviously tortious claims are in essence based on the idea of fault. And when you don't have many humans aboard the vessel doing things, executing decisions, when those decisions are given, transferred to algorithmic decision making, how the fault concept can apply meaningfully in that kind of situation is obviously a very important and complex matter to look into. So the ideas there, obviously, when we have got mass and when decisions are autonomously being executed by algorithmic systems, one of the key problems that is likely to arise is the situation of the victims. So how are they going to establish causation? So that will require knowledge and understanding of complex technologies, and they may not be equipped to understand that. We're not even talking about the idea of obtaining the evidence. So how are they going to get hold of the evidence to establish causation? And if they get it, let's say, even if you have got a situation where your defendant, your ship owner is quite cooperative, let's say, just threw everything at you, all the information. So how are you going to interpret it? How are you going to find out what actually caused the problem? You will need to incur some expenses, perhaps get some IT people to sort out that mess, to identify the cause so that you can embark your claim. So because of the complexity of these technologies, litigation can be problematic, also arbitration as well. So establishing causation might be a problem. So the paper obviously acknowledges this fact. Also the issues about burden of proof as well. So if you're going to establish on balance of probabilities, again, you have got some evidential difficulties there to interpret all those complex technological stuff, document it, and you have to make some sense to establish your causation, to discharge a burden of proof as a claimant. It may be difficult. And how fault as a concept, the extent to which it actually makes sense, it's also a bit questionable when you have got some machinery, when the decisions are ultimately taken by these machines, and when the programmer's role is only to program these things and without necessarily being able to control the exact particular decisions taken in each instance. How you're going to attribute fault is another problem. There may well be occasions where it may well be possible to point your fingers at somebody to say, well, this person's at fault. It may not always be easy. So the paper, therefore, looks into those problematic areas, acknowledging the complexities arising from the operation of mass for the purpose of resolving liability issues, what should be our approach. So strict liability is one thing. So within the group, there was some appetite for that. Other alternatives were also covered in the paper. So maybe there could be some procedural relief that can be given to claimants, maybe. Some burden of proof, for example, can be alleviated. Presumed fault can be acknowledged so that claimants may well have less work to do. Maybe the burden may well shift if there is, obviously, if you speak of presumed fault, that will be the case. So it will be on the defendant to show that he played no role, he had no fault on whatever happened. So presumed fault might be an option to choose. So establishing fault at ease. So obviously in each and every jurisdiction, we have got our procedural reliefs that can be granted to claimants. Like one of them is, the Latin maxim, so res ipsa loquitur. So you look at the facts and say, well, looking at the facts itself, it speaks for itself. I can see the fault here. So the claimant doesn't have to prove anything. So res ipsa loquitur kind of approach can be taken by the courts when there is some action, some dispute about a liability matter. Or how we define fault is actually is dependent on us, on jurists, on judges, on arbitrators. How is the fault liability to be established. So if there is some non-compliance with the rules and regulations related to, let's say, certification, training, etc., of these algorithmic systems, then you can attribute some fault. So that's one way of looking at it. Well, yes, we no longer deal with humans, but some liability can still be some liabilities can still be sorted by being able to point our fingers at those who failed to deal with necessary certification requirements. I obviously refer to the ship owners who, let's say, failed to make sure the system is properly updated, etc. So fault, yes, it may well be difficult to establish, but perhaps in many instances may not be entirely impossible. So because it's really all about how we approach the concept of fault and how we can establish it still, maybe, when we have got a commercial operation of mass. So other idea is just leave that problematic concept to one side. Fault may not make much sense when we have got algorithmic decision making taking place. Let's just stick to strict liability. So that's obviously another option, and that option also was covered in the paper. So is there necessarily a correct approach? It's difficult to say, but the paper, if you read the research paper that was submitted to the IMO, the CMI paper, there is some support there for strict liability, or at least some presumed fault, so that the burden on the claimant's shoulder can be alleviated. Any views on contractual liability issues raised in the paper? The answer is no. So the paper actually was mainly focused on tortious liability issues, how to resolve them, what would be the best approach to take. So to resolve general tortious liability issues when the mass is in operation. So that was the main focus. We certainly do need some work, I think, also on contractual liability issues. Perhaps some position paper might be useful to express our views on what we should do with the Hague-Visby rules, whether it needs some updating, whether it can still be made compatible with some stretching by giving it some flexibility, or should we just forget about it and start something new? So I think it's been some time now, but I did talk about this topic at the recent CMI conference. The question was obviously whether the Hague-Visby rules, whether they can still survive mass, or whether the rules should now change. So it will always be difficult to get engaged in any legislative activities and to change a convention like the Hague-Visby rules. Well, there have been recent attempts, didn't work that much. It will require a lot of work, and nobody knows whether that will be successful in the end or not. So it might be worth thinking of some ways in which the Hague-Visby rules can still be made applicable, stay relevant in the new era. So that could be a possible approach to take. So my final slide on next steps, so it's 14. So what happened? So the research paper drafted by the CMI was submitted this year in April to the legal committee at the IMO. The IMO's view was that because there were some complicated liability issues, detailed, complicated liability issues were raised, the majority view was that it would be too premature to delve into these complex legal matters. And they have shown some preference for the completion of the MASS code. So there is now a draft MASS code that is being worked on by the IMO. The MASS code doesn't contain a lot of legal intricate discussions, issues, rules. So it's more sort of a general code looking into issues like certification, training, etc. It's not finalized yet. But there is one draft which I'm not able to share with you. It's a lengthy one, and it's more technical in nature. So there is no discussion on the regulation of the intricate legal matters that we eventually have to tackle with. So that's obviously ultimately what we need to do. And I think for that reason, CMI's role is quite important. IMO obviously deals with more wet shipping matters, safety aspects, technical aspects. They have got a prominent role in the regulation of those kinds of matters for the shipping world. But CMI also has got this critical role in dealing with commercial regulation of commercial matters. And what we can do is, in addition to assisting IMO with the codification of the MASS code, which we do, there is also this need, and I think some important, meaningful steps have already been taken with the research paper on tortious liability. Some position papers also, I think it will be important and necessary for the CMI to do some position papers on the liability issues. So I think more work can be done on that, and quite likely there may well be some more work to be done on those matters. Maybe some work on contractual liability issues. Maybe we can expand the tortious liability issues and write other position papers on those matters. I think that will be quite important to do for the work of the CMI. Because yes, it makes sense to help the IMO with the codification. It's important to have our say, but I think it's also important to express our views on the matters, civil law matters, let's put it this way, so contractual issues, liability issues, and how are they going to be resolved when we have got MASS. I think CMI has got this important, prominent role to gather ideas together, express some views. They don't necessarily have to be very strong views about which way to take and what should be necessarily the way forward. But even, in the form of some recommendations, in the form of a position paper, I think those are important activities for the CMI to take in the future, looking beyond, and quite likely there will be some further work on those things as well, or at least I hope there will be. Thank you very much.
Thank you so much.